Joe's total bill is $214. Do you see that?
Yes.
Next to the first lock change says $107, correct?
Yes.
Next to the second lock change says $107, correct?
Yes.
And then that equals $214. Is that correct?
Yes.
So Miss Blair, it appears that she's attempting to
Bill me to
charge you to when she locked you out of the house.
Objection, Your Honor.
It says Joe's total bill.
This is not an attempt to charge him.
It says Joe's total bill.
Well, it just says what it says.
No further questions this time. We pass the witness, Your Honor.
Mr. O'Donnell, if you turn to Exhibit 1 in the book. In this document, there's no amount for the lease payment per month, is there? Of any nature?
No, this is a temporary thing. She just wrote in her car real quick, so we'd have proof to go in the house and get utilities, do whatever.
Okay, no down payment mentioned in there?
No,
No closing date?
no, this is just a lease.
Okay, but how long, is there a lease term?
No, we knew that we were coming up with the
Okay,
official.
Just a
lease.
minute,
This is temporary.
Sure,
just
answer
a
my
minute,
question,
yeah.
if you would, please.
Don't argue with him.
Oh, sorry.
The
No,
question can be answered yes or no.
Oh,
If he
sorry.
wants further explanation, he'll do that. This is a different kind of examination. This is from opposing counsel. He's gonna ask you straightforward questions and try to give straightforward answers. Don't explain unless you're asked to. If you need to explain, Mr. Hatch can come back on redirect.
And it doesn't say when the option is to be,
no.
when the purchase is going to be optioned or the option is going to be taken care of. Now, you said you had a verbal agreement back in 2020?
Yes.
Okay. And that was never reduced to writing?
No. I mean, well, I mean, yeah, no.
Okay, thank you. Now, turning to the actual lease option is exhibit,
18.
yeah, you probably know that better than I do. This is a rocketlawyer.com document. Did you access rocketlawyer.com to obtain a copy of this?
Yes.
Okay, so you're the one who got this agreement.
Yes.
Okay. And you filled in the parts of the document that were probably empty.
We went over it together. She was on the phone with me the whole time. We were sending pictures back and forth.
She was on the phone, but you were right at the computer with the document? Is that how it went?
Initially, then we just brought it over to her house to review it.
So you prepared this document, in other words?
Yes.
Okay. Have a lawyer look at it?
No.
Now, the document provides that you have certain obligations. And I address your attention to page 2, maintenance, which is in bold, and below that, taxes. Okay?
I see it,
You
yes.
see it? Okay, thank you. And have you ever paid taxes on this property?
Yes, I have.
When?
I believe it was 2021.
Did you pay?
I paid the property taxes, $5,000.
2021,
I believe so. Or so- I don't know if they were 2020 taxes or 2021 taxes. I'm not sure.
2022 taxes? Have they been paid?
No, we were kicked out.
2023 taxes?
We're still kicked out.
You've been back into this house a number of times, but when did you come back permanently? When was that?
I don't understand the question. I'm sorry.
Well, you've been living in the house since when?
I still don't. What do you mean? What are you talking about?
Well, after my order that said you could go back in, when did you go back into the house?
We're not really back in yet. All the pipes were busted, so we were working on the house for 2 weeks, and then we had to go put needs a new furnace, it needs a new I mean.
The pipes froze?
Oh, yeah, all of them were. The furnace was out. She didn't have the furnace on. The cap was off the furnace. The furnace was toast when we got in there. She left the place. It was destroyed.
So I wasn't aware of this. So the pipes froze, then they thawed out. So did the house flood?
No, it did not, luckily. And there was some water damage, but it was mostly contained in the bathroom walls. We had to knock out 2 of the bathroom walls. We fixed the cracked pipes in the walls, and then we had to fix under the tub. And I think there's like 15 different breaks in the basement and the crawl space under the house. Almost every elbow, but either blew off or cracked. It was a big mess. I mean, my guys were down there for 2-3 days almost full time.
So the bottom line is, after Judge Middleton said you could go back into the house, you haven't.
It's not habitable yet.
Oh, that doesn't answer my question. You haven't lived
I
back
don't
in the
understand.
house.
Oh, I'm sorry. I don't understand your question though. How we can't live there? I mean, how can we go back in if we don't live? We can't live there.
Well, you can say, I don't live there. I
Well, that's
haven't
what I
lived
tried
there.
saying. That's what I said. We don't live there.
Where do your kids go to school?
Joey O goes to Notre Dame Elementary in Long Beach, Indiana.
With his mother?
Yes, Grant goes to Christian, and he's in kindergarten at Christian in LaPorte, Indiana. Joey Bowers is at New Buffalo Elementary School, or he's at the middle school. And Kenna's going to be at the middle school next year. Laney's at the elementary school, and like I said, Grant's at the LaPorte.
Okay. In other words, your kids are going to the New Buffalo schools by and large, not all of them, but some.
Mine are going to Indiana schools. Her 3 are going to go.
Oh,
to
Miss
Buffalo.
Bowers is
Yeah.
going to Buffalo. And where are you living at these days?
Right now, I'm at 28 North Barton Street, New Buffalo.
Are you renting or do you own that place?
I own it.
Is this one that you were going to fix up and sell?
No,
No, you just planned on,
I just rent. I don't sell. I don't sell my own property.
okay. So you're living there now. Okay. Now, one of the portions of the lease option provide that page 4, towards the top of the page, option to purchase. No, never mind, that's the wrong one. Oh, oh, option consideration. I got go down a little bit. Can you find that?
Yes.
And am I correct in reading it says non-refundable option consideration in the amount of $5,000 paid by the tenant as consideration for this option to purchase agreement? Am I good so far?
Yes.
Shall be credited to the purchase price at closing if the tenant timely exercises the option to purchase.
Yes.
If the tenant doesn't exercise the option to purchase, the tenant shall forfeit the non-refundable option consideration. Is that part of the money that you have given Ms. Blair?
No, I don't think so. Yeah, that was just if she just kept $5,000, but didn't terminate the contract, right?
But have you given her that money?
The $5,000?
Yes.
Yes, that's part of the.
So it's part of that money that we see on that blackboard or that whiteboard?
I'm not sure.
Well, why not? Why aren't you sure, sir?
I can't tell you. I'm not positive about that. I think. Yeah, it should be. Yeah, it is.
Okay, can you point out where it was given?
It would have just been included into the funds. I mean, we probably just wrote this into the contract. It's $5,000 towards the end of the contract. You know what I mean? Like we just assumed this. This was no money was never really paid. It was just in the amount of money that came to her through her deposits and everything else. And we just wrote that number down. So it'd be fair if something happened. She'd have $5,000 at the end. So it would be fair.
Okay.
That's what I believe. I mean, that's the fairness thing. I mean, that was,
Well, if you don't close the option here, she should keep that $5,000, correct?
yes.
Okay, thank you. Now, you have a habit, it's a good habit, I think, of taking pictures of the cash that you gave Miss Blair.
When it was available. Yes.
I mean, we've got pictures here and so forth, and your counsel has asked you to put green dots in there.
You can't break cameras out at the casino though.
Well, what you say that you gave money on January 31st,
Yeah.
14,500 cash,
Yes.
Exhibit 12.
Yes.
Can you turn to Exhibit 12? What it says up on this screen here. Exhibit 12. I'm looking at Exhibit 12, which appears to be a screenshot of a text conversation. Am I
Yes.
okay? Anywhere in there that says you giving her $14,500.
No, it says right there, the 14,000, and we gave her 14,500. I wrote it down wrong. I was texting her. I mean, it's a pretty common mistake.
Oh, so that's a mistake.
Not a mistake. I mean, yeah, or a omission, one of the two. I'm not sure. I mean, I paid her 14,500. I mean, I have the proof of the payment.
What, you got a picture of that?
I have something with the cash on there. I took the cash out from my account. Yeah.
Well,
I don't know where it's at.
in your summary, there's a blank for the exhibits.
Oh, okay.
So there is no exhibit indicating
Oh.
that you did in fact give Miss Blair $14,500 on January 31st, 2022.
Objection, Your Honor, mischaracterizes the testimony. He verbally testified after the
Yes,
text
but
message.
I guess there's no photograph of a receipt or the cash, that 14 or 14.5 that you gave Miss Blair. And that says January 31st. You don't have a photograph of that. Now, did you give it to her inside the casino?
No, this cash I gave to her at her house.
Okay, but you don't have a photo of that?
No. You know why? This time we were both wearing masks. When I came into her house, I couldn't even bring a camera. I met her at her front door to pay her on this time. And this is when she had the contract.
Okay, you're not asked a question.
Oh, no, I was just sorry, I was talking about it in my head.
Okay.
Just because there may have been COVID doesn't mean you couldn't have brought your camera along and taken a picture of the money. You could have done that, couldn't you, sir? If you gave Miss Blair $14,500 on January 31st, 1922, or 2022, excuse me, there would have nothing that would have prevented you from putting that cash somewhere and taking a picture of it.
Yes, it
Objection,
would.
Your Honor, forum foundation calls for speculation.
He can answer the
I
question.
was in the hospital the next day. That's how sick I was. When I said I was sick here, I went and got a COVID test before I came over. I was ready to throw up on myself that day when I showed up with that money to pay her. I walked in her door.
Again, that didn't answer the question. You could have taken a picture if you'd had the presence of mind or made the
Yeah,
extra
I
effort
wasn't
to do that.
Okay, so you didn't.
No,
Okay. Now turn to Exhibit 13. Is that a group of text messages?
yes,
And the top date is March 9th, 2022?
yes.
Any indication that there was $2,000 cash given to Miss Blair on March 9th, 10th, or 11th?
No,
Any photos of that? Did you ever take a photo?
no, I was at the casino.
You could have taken a picture before you went into the casino if you were.
I have
into-
things with the money taken out of the bank. I have receipts from the ATMs in the bank.
Again, that didn't answer the
Oh,
question.
I didn't know what he meant.
All right.
No, I did not. No, we were at the casino. You can't break out phones in the casino. It's kind of-
Right, but my question was, before you walked into the casino, knowing that you were going to give Miss Blair $2,000, you could have sat in your car and taken a picture of the money, could you not have?
I mean,
Objection, Your Honor, forum foundation calls for speculation.
He can answer the question. Don't fight it, just answer.
oh, I
it.
mean, I
You could-
suppose,
you
yeah, I
could
mean,
have.
I could have, yeah. I mean,
Yeah,
yes.
all right, that's all he's
Okay.
getting.
Then let's turn to Exhibit 14. I think that's also a group of text messages. The top one is April 12th, sorry, of 2022. You are claiming that you gave Miss Blair $2,000 on April 12th, and that you basically backed that up by referring to exhibit number 14. Exhibit 14 doesn't have any indication of any money being given, correct?
Correct. Yes.
Okay, I'm sorry. You may have to speak up.
Oh, sorry, I'm sitting back.
That's
here.
okay. And once again, you didn't take a picture of it, of the money.
Not the cash, no.
Okay, turning to exhibit number 15. Let's see, that's also seems to be a
This,
text messages.
Objection, Your Honor, this exhibit's not admitted into evidence and
Well, he can still ask him about it.
what's
Well, it's
I
a,
was no part of this one.
beyond the scope of direct, Your Honor. We skipped this one. This is going to be for Ms. Bowers to testify.
So there's no issue with beyond the scope of direct. He can examine as to anything. But at least the text messages, is this? Oh, this is Carla. So yeah, it's not you. I got it.
okay. Okay,
Let me clear up the objection. Lack of personal knowledge, lack of foundation.
Okay.
fair enough, Your Honor, I'll withdraw that. Okay, turn to exhibit 16, which is on the board there. As you gave Miss Miss Blair money on June 9th of $2,000 cash, and you use exhibit 16 as a reference for that? That's on the board there, isn't it?
What's that? I was looking at this. What are you talking about? I'm sorry, you lost me there. Where were we at? Can you repeat that?
If you look at the board,
Can you
exhibit,
repeat the question? I tried, they lost me.
okay, slow down, I'm not trying to
Okay. I'm
do
just
anything
asking,
but
repeat the
ask you
question.
questions. You look at the board there and you got exhibit 16, right?
Yep.
You got a green dot,
Yes, I do.
and that green dot is supposed to represent you giving Miss Blair $2,000 cash on June 9th.
Which I did.
Well, take a look at exhibit 16 again. Any mention of money there?
Desperate for cash. Need cash now.
Does that say $2,000?
Oh, no, it doesn't say 2,000. There's mention of money though, cash.
Oh, okay. Does it mention that you gave her money?
It says thanks.
And did you take a picture?
No.
Okay. So there's quite a few of these that you never took a picture of, and there's nothing in the exhibits indicate that you gave that money to Miss Blair, but you want the judge to count it, don't you?
Objection,
question.
Your Honor. Assumes facts, not in evidence that.
Well, he can just answer yes, even though you didn't take a picture of it. You want me to consider that as money paid. Is that true?
Yes, of course.
At some point in time, and I'll ask you to focus on November 15th, 2021, where you say you gave Miss Blair $14,400. Did you ask for some of that money to go back to her?
What do you mean?
Get returned. Did you ask money to go back to you?
Oh, you said go back to her.
Oh, I'm sorry, go back. I apologize. In other words, out of that 14,000, did any money go back to you?
No.
Was it another time when money came back to you from money that you gave to Miss Blair?
Money never came back to me.
Oh, so every time you gave her some money, she kept it.
Yes,
Okay. Do you have a checking account, sir?
yes,
And you were giving Miss Blair, according to your testimony, significant amounts of money at various times. Why didn't you use the checkbook?
she wouldn't take checks to her bank. She would not use the bank system. She made that very clear to Carla. Then.
Well, you would agree with me that a canceled check would have been the best evidence you could possibly get
Not better than a picture.
outside of a picture
Yeah,
when you did take the
yeah,
pictures.
yeah.
Okay. Now, when you say you were ready to purchase, were you working with a bank or a credit union?
Yes.
What was the name of the bank or credit union?
I think it was First American Heritage.
And where are they located?
I think that branch is out of like California or something like that.
Do they have a local office?
No.
Did you apply for a loan?
Yes, and Carla applied too as well.
Okay, did you separate loans or both of you combined?
I never finished my application process. I was in the beginning of my application process, but I didn't follow through with my final application because I didn't want to get the ding on my credit yet. But I had everything lined up just to that point.
Okay, so you never made the application.
Well, I made an application. I didn't fill through with it. I mean, I can show you the stuff. Yes, I don't know how to answer that. Yes, I talked to the guy. I was in time with him. He got all my information. We were back and forth on everything. He wanted to get the hard run of my numbers and everything. I waited up because Carla was going to go through with her stuff. And then I was waiting on her to see who'd get a better deal. We thought Carla would get the better deal. So we're going to go with her.
So you didn't then sign documents that says, I will pay First American Heritage whatever amounts of money they give me for a mortgage?
Not yet, no.
Not yet?
Well, we didn't have the opportunity to get the mortgage. She wouldn't sell us the house. How do we get the mortgage if we don't have the house to buy?
You said you were ready.
We were.
Well, ready means you have, approval from a bank or a credit union.
Objection to form, Your Honor. I don't know if that's a question or if it's testimony. It also makes.
Well, he didn't have the cash in hand, but his testimony was he had started the process and he certainly had time to complete it before all things went sideways.
Carla had done it. She'd done like the actual app. We didn't both have to get a.
All right.
Right?
So you and Carla were working on financing for the purchase,
Yes.
but had not completed it or got a confirmation.
Is that true, what the judge said?
I had not gotten a confirmation. I believe Carla did.
Okay. And how much were you asking for the loan? Or what you would have been at, or miss?
It was like 355 or something, or what was it? I forget what the balance was, or the 335 or whatever it was for the balance. I believe it's 330. I gotta look somewhere to find out. I don't have it offhand. 335 or something.
Okay.
What's 112 minus 450?
Okay, we can do the math. And what, is there an interest rate that you were given, or?
I
Didn't
believe
get
you
that
have to ask
far.
Carla about that. I don't remember what that was.
Okay. And you never got approval for the loan, did you, from the?
Carla
bank?
did.
I understand that, but my question is, did you?
No, I said that.
Okay, thank you. When the folks from Fabius Township came out, and I'm going to refer you to your council's exhibit number 23. You see the red placard,
Yes.
and you can read it. It's condemned, dangerous, keep out, so forth. Was that placed on your house? On the house at
Yes, it
Lakeshore
was.
Drive? Okay. Did you see that at any time?
Yes.
Okay. Did you take that condemnation notice in red off?
No.
No? Did Ms. Bowers or somebody else do it on your behalf?
I didn't witness anybody do it. No.
But
It
did
did get removed. It's not one of them did. The one off the front, but not the one off the side.
Okay, one of them got removed.
Yeah.
And you don't know who removed it? Okay. And you notice that the green notice of violation is a couple days later, I think August 15th. Am I reading that correctly, you think?
Yes.
Okay. And
Objection, Your Honor. Mischaracterizes the testimony. Or excuse me, mischaracterized the exhibit. I think that date is 8/15 for both of them.
I believe it is too.
And also, I'm trying to give opposing counsel some leeway here. I don't see any relevance about whether these notices were taken off, what that has to do with specific performance. So I'd like maybe some clarification about where we're going with this line of questioning.
well, council brought it up about how these things were so stressful and horrible and so forth. And I wanted to get into that a little bit because obviously one of the red placards was removed. And I want to know if he knows why there is a green placard after that.
I don't see.
I believe they're both the same date.
I don't see a logical connection between the stress of being.
Oh, he
kicked out
can
of the
ask.
property.
You went down that path. I'll let him wander down it a little bit himself. It's not gonna help me any, but it might make you feel better, so go ahead.
Was there a question? I'm not.
I'll withdraw my objection.
Thank you. Now, you indicated that you went back into the house even though the locks had been changed,
Yes.
okay? And the exhibit that your counsel provided was exhibit 24 that indicated that on October 14th, Mr. Fish had changed the locks. Is that, you think I read that right?
Yes.
And you testified to your counsel that you got in there on October 15th, the next day.
I believe so. Yes.
Well, you drilled the lock or did you bust the window? How did you get in?
Oh, to get in the garage? I
Well-
just drilled through the lock.
Okay. Did anybody give you permission?
My house.
I see. So the answer is nobody gave you permission.
I don't need permission. Oh, yeah. No one gave me permission. Sorry.
Thank you. And the locks were changed another time. Did you go back in after that?
Yes, it did.
Okay. Anybody give you permission?
Myself.
Okay, fair enough. In other words, you kept breaking in and the locks kept
I
changing.
kept going into my house.
You didn't need anybody's permission. You were there under color of lease. The lease had not been terminated by a court order, by me, or by a writ of eviction. There was a pretext of a condemnation, and the condemnation had been lifted. So at the point the condemnation was lifted, you had the availability to go back into your house. The actions of the defendant very clearly violated the landlord-tenant lockout law, which we had made a finding. It's also part of the default. So don't go down the path. You had every right to go into the house on those dates under the color of your lease option to purchase. And you didn't need permission to go in there.
Well, one of the questions I think the judge asked, and I'll ask it as well, is do you ever receive a bill from Miss Blair for the changing of the locks?
No.
Okay. And that was maybe 8 months ago, at least. Okay, thank you kindly. Nothing further, Your Honor.
Thank you, Your Honor. Just briefly for redirect. Mr. O'Donnell, could you turn to Exhibit 18 for me, which is the lease with the option to purchase? And on cross-examination, I believe you were asked questions to the effect that you prepared this document, correct?
Yes.
Did Miss Blair give you any input on this document?
Yes, she did.
You didn't force her to sign this document, did you?
No, we did not.
Did Miss Blair review this document?
Yes, she did.
Did she review this document in your presence?
Yes, she did.
Did she give you feedback on this document?
Yes, she did.
You didn't have a gun to the back of her head and force her to sign it, did you?
No, we did not.
You go to page 5 of Exhibit 18. You see the paragraph titled Acknowledgements.
Yes.
That paragraph states the parties are executing this option to purchase agreement voluntarily and without any duress or undue influence. The parties have carefully read this option to purchase agreement and have asked any questions needed to understand its terms, consequences, and binding effect, and fully understand them, and have been given and executed a copy. Do you see that?
Yes, I do.
And on the next page, page 6, Ms. Blair signed this document, correct?
Yes.
What more could you have done to have Ms. Blair understand this document?
I don't know. If anything else could have done.
And that acknowledgement states that Ms. Blair carefully read the document, correct?
Yes, and we had it notarized in front of a witness.
And it says that she could have asked any questions she needed to understand its terms, correct?
Yes.
All right, on cross-examination, you're asked about taxes, property taxes about the property. You recall that?
Yes.
Okay. What date were you kicked out of the property?
We were kicked out of the property in August of 2022.
Okay. After August of 2022, you haven't paid property taxes, correct?
No.
Why would you pay property taxes on a property you were kicked out of?
I shouldn't.
What about 2023? Have you paid property tax in 2023?
No.
Have you been ordered by the court to pay property taxes for 2023?
No.
Again, you don't actually have title to the property right now, correct?
No, I did not.
So why would you pay property taxes for a piece of property that was subject to litigation?
I don't think we're required.
There was some testimony about the condition of the house when you were finally able to come back to it after the court premises. Do you remember that?
Yes.
Do you recall when the court entered the order allowing you to occupy the property?
It was like April 27th.
Can you describe the quality of the property at that time?
It was pretty bad, rough shape. You could tell that no one had been there in a few months. You know, the judge had ordered no one in there, and but they've taken the water heater and all the pipes. The furnace was never turned on. It was left the furnace shut off, and the cap was off the furnace and everything. But I went to turn on the water filter to turn on the water to the house, and you just heard it spraying out across the basement underneath the house when the water pump came on. So we got underneath there, saw multiple leaks, and then there's leaks in the wall going up in the master bathroom. There's leaks underneath the kitchen sink. There's leaks in the bathroom, the washer and dryer room, and there's leaks everywhere, almost every elbow. And I think I have pictures, but there's close to 15 to 20 actual breaks, not to mention another 10 probably elbows that's got knocked off.
In August of 2022, before you were kicked out of the house, did you have the water on?
Yes, everything.
Did you have the furnace on?
Yes, everything was running.
What was
perfect.
the condition of the house? Was it okay?
Everything was running perfect.
Okay, and then after you were kicked out, you had no control over maintaining the utilities
No, we
of the
did
property?
not.
And Miss Blair had access to the house after
Yes,
August, correct?
exclusive, yes.
And then, so in between August and April, you didn't have access
Not at
to
all.
take care of the house, right?
No, not taking care of the house, no.
And this will go to our money damages, but have you actually obtained a quote to make all the repairs that are necessary to repair the damage to the house?
Yes,
And just generally describe what those repairs are. So you talked about pipes, water pipes.
okay, well,
right?
there's multiple water pipes in the basement, and there was fixtures in the bathrooms where the actual faucet heads had blown off.
Excuse me, Mr. Snowdown. I believe this is beyond the scope of prosecution.
Yeah, it is, but, so there, we'll know there'll be additional damages. I do have a question. What was the source of, fuel for the furnace? Was it a gas
Gas
line?
forced air,
Is it propane,
gas forced air, like regular natural gas,
natural gas pipeline?
yes.
Okay. And once you were forced out, did you ever pay any gas bill?
Carla, I didn't know. Carla did.
All right.
That's a quick question.
Well, you can ask, we'll see whether.
I just didn't know who I'm answering. Like, if you asked me, like, did you pay it? I'm like, no, I didn't pay it.
The beautiful part of my job is that I don't have to answer questions.
Okay, yeah, no, I didn't know if she, I forget. It's
All right,
not-
anyway,
That's-
I wondered whether there was a propane tank that perhaps ran out of propane or,
No,
in filling counsel in, previous counsel were involved in the matter at that time. There was a hearing set in January. And the matter was adjourned as I think Mr. Hauser came in. And then it got adjourned again by stipulation of the parties, I think a couple of times. And then we had I think we had a snow day. One of the days, and then we had a tornado day, but this was supposed to be dealt with right after the first of the year, and for a combination of reasons, it was not. Any further questions for this witness?
Yes, just briefly, Honor.
Mr. Soltis, you had an issue,
Well, my objection, Your Honor.
which
I
was,
can-
oh yeah, which I granted, we don't,
I can move on, Your
I'm
Honor.
curious, but I don't need to know that for this purpose.
Mr. Soltis went through with you, Mr. O'Donnell, on page 4 of Exhibit 18. There's a section titled Option Consideration. You see that?
yes,
And that states non-refundable option consideration in the amount of $5,000 paid by the tenant as consideration for this option purchase agreement shall be credited to the purchase price at the closing if the tenant timely exercises the option to purchase. Do you recall Mr. Soltis asking you some questions about the $5,000?
yes, I do.
Look on that demonstrative in front of you. What date was the lease with option to purchase
It's on
executed?
November 15th.
Okay. Did you make a payment to Miss Blair? on
Yeah,
November
14,400.
Okay. So was part of that payment the $5,000?
Yes.
For the option?
Yes,
And that states that it shall be credited to the purchase price, correct?
yes, at the end.
So it's not like it was an addition to the purchase price. It was going to come off the $450,000.
Yes,
And it says if the tenant timely exercises the option to purchase. Do you see that?
yes,
So do you recall your testimony when Ms. Blair sent you a text message on or about August 4th stating that she wanted to close on the property?
yes,
And then do you remember responding to that text message with confirmation that you intended to close on the property?
yes.
And how long did you have to close on the property?
3 months.
Could you have even closed on the property after August 4th?
Objection, speculative, Your Honor. He didn't finish up the application with Heritage, so he doesn't know if they would have approved it or not.
Well, was it your intention to close within those 3 months and?
Oh, yes, it
finalize?
was.
Would you close on a property that you were wrongfully evicted from?
No,
So if someone kicked you out of the house, why would you close within 90 days and pay her more
I
money?
wouldn't
after
give
she
her any
kicked you?
money, no.
So because of Miss Blair's breach, you didn't have the opportunity to timely close on the option of the house. Is that correct?
Yes,
All right. You remember going through a lot of Mr. Soltis's question about there's no pictures of some cash payments. Remember that? Okay. And one of them was January 31st. That was a larger cash payment of $14,500, correct?
yes,
Okay. And the rest of the cash payments were $2,000 installments, correct?
yes.
Okay. just because you didn't take a picture of the cash that you paid Miss Blair doesn't mean that you didn't pay her the cash.
Objection, and I think that's this court's decision, not Mr.
Yeah,
Oh, yeah.
he testified that he gave her the money, and he testified that he didn't take a picture of it. And so it goes without saying, just because he didn't give a picture doesn't mean he didn't pay it. So he alluded to other evidence like bank records or something, but none of that is in evidence. But yeah, that's a question that doesn't even need to be answered, because his answer is going to be yes.
Your permission to approach the witness.
Yes.
Mr. O'Donnell, this is $5 of cash. You see that?
Yes.
I'm not taking a picture of it. Can you pick it up?
Yeah.
Just because I didn't take a picture of that, does that mean that I didn't pay you?
No.
Okay.
I can't keep.
Okay.
There is a picture of it. It's on video HD quality.
And Mr. O'Donnell, on your phone, do you have a picture of $14,500 of cash?
Yes, in my lap.
And is there a way to tell the date that picture was taken?
Yeah, the photos you take on an iPhone give you a digital tag on them. They tell you the time, location, and date photos.
Could you bring that picture? Can you make that available so that the court and the opposing counsel could see that? So
Yeah.
sure. You have permission to approach?
Yes.
Photograph.
Oh, absolutely.
Here's my COVID test for it. And here's the cash.
We can all look at.
I'll let the judge take a look first.
Monday, January 31st, 10:30 a.m., low battery. It shows some, looks like hip hop videos of stacks of $100 bill.
That's not how it is, Your Honor.
I think it's closing up on me right now.
No, look at it. Let's go like that close.
You asked me why I
Oh, I'm
didn't
sorry.
take
Oh,
pictures,
geez,
but
I hate these phones. I don't know how to work them.
Let's go back to it here. Can you go back to that picture?
try it.
Mr. O'Donnell, this picture is large stacks of $100 bills of cash, correct?
Yes,
How much money is in there?
this one is 10,000 in that bundle.
How much is on the bundle on the left?
I believe that is 4,000
4,000 or 5,000?
or 5,000.
Somewhere around there, correct?
Yes,
And what's the date that this picture was taken?
January 31st, 2022 at 10:30 a.m. Let's see where it's taken.
Is that the money that you gave to Ms. Blair on January 31st?
Yes, it is.
There's a couple options here. I don't have a physical copy of the exhibit, so we can either ask the judge to take judicial notice of it, or we can supply a copy afterward. But we would ask that be exhibited, or admitted in evidence, Your Honor.
All right, we'll call that exhibit 25.
And I would object to that, Your Honor. We had all the exhibits here and suddenly this one appears out of the blue. It doesn't have any indication of the actual amount, and it doesn't have any indication that it was given to Rosemary Blair.
All right, over the objection, he can email it to you, you can print it and make it part of the file.
Thank you, Your Honor. You were asked some questions about a loan application that you started in August of 2022, correct?
Yes.
And that loan application was for the remainder of the purchase price for the property?
Yes.
That was through First American Heritage, correct? What was the date that Ms. Blair sent you the text message to close on the property?
August 4th.
And what was the date that you were kicked out of the property?
I think it was August, was it August 12th?
Around August 12th?
Yes, I think it was 12th or 15th, I forget what it was.
Does August 15th make?
Yes.
Well, let me refresh your refresh your recollection. You go to exhibit 22. Is that a condemnation notice that we went over previously?
Yes,
What's the date on that?
August 15th.
Okay. Does that refresh your recollection?
Yes,
Okay. When were you kicked out of the property?
August 15th.
Okay, so August 4th and August 15th. There's not a lot of time to submit and be approved for a loan application during that period of time, is there?
No.
Objection, Your Honor. I don't think this witness has that knowledge as to whether or not a loan could have been finished and approved within that time frame.
I can lay a foundation, Your Honor.
We don't need to go dance on that ballroom floor. Obviously, you're not gonna have $338,000 loan in 9 days. So it just speaks for itself. The notice was on August 4th. And that was a Thursday. The zoning citation was August 12th.
That's what I thought, yeah.
So that's six business days.
Mr. O'Donnell, after you were kicked out of the house on August 15th, do you have knowledge that Ms. Bowers applied for a loan to purchase the property?
Yes.
And why did she apply for that?
Be here to say, Your Honor, Ms. Bowers is here to testify.
No, I'm not offering it for the truth of the matter, sir, Your Honor.
All right, you can answer.
She had to buy another house to live in. She needs somewhere to live. She bought a house for $469,000.
Do you have personal knowledge that she applied for a loan to purchase a different property?
Yes.
Because you're dating Ms. Bowers, correct?
Yes.
Do you guys discuss your personal
Yes.
finances?
Yes.
And that was to buy a home after she was kicked out of 11247 Lakeshore Drive, correct?
Yes.
Do you know whether she was approved for that loan?
She was.
Okay. Did she buy a house with that loan?
She did.
What was the amount of that loan?
$469,000.
So that loan exceeded $350,000, or excuse me, $338,000 that you guys owed under the land contract, or excuse me, under the lease with the option to purchase. I apologize.
Yes.
At a certain period of time, are you aware that the condemnation was lifted by the court
No,
for
we
the
were never
property?
notified.
Well, but are you aware that at some point in time there
Yes.
was? Okay. After the condemnation was lifted, were you ever informed?
No.
Did Miss Blair ever tell you you're welcome back in the property?
No.
Instead of welcoming you back in the property, what did Miss Blair do?
Called the police. Officer.
At a certain point, did you actually file a lawsuit for an eviction of the property?
Yes.
For you? And that was a property that she was already in possession of, correct?
Yes.
No further questions, Your Honor.
I may, Your Honor.
Yes.
Mr. O'Donnell, you had to find out that the condemnation was lifted at some point in time.
In court
Okay, and so the court told you that.
in December. Yeah.
Okay, in December, you knew that the condemnation was lifted.
Yes.
And you could have gone back in there and.
No. He wouldn't let us.
Well, he testified, he tried to go in November and October, and the doors were locked, and she called the state police. So he attempted to go back in after the condemnation was lifted, but was unable to do so.
But if it was lifted in December, Your Honor.
No, it was lifted before December. It was lifted, I believe, in September.
Your Honor, I believe that your order of September 6th says that nobody should be in the house.
Yeah, and at some point it's lifted. September 6th. Cannot be occupied. Consented to by the plaintiff. There's no mention in here anywhere of a tenant being in there. That was, and I was unaware there was a tenant in there. I feel, as I said, embarrassed. Ms. Blair is dealing with this as the property owner. There's no knowledge by the court that there's a lease option to buy. And I don't have the actual zoning file in front of me. I can't tell at what point it was lifted. I have a note of it somewhere. I think it was earlier than November.
I think it was done through a consent judgment, Your Honor, and Roxanne Sieber was the township's attorney.
Yes.
I think that's the September 6th one that says no.
That was the September 6th order. that Miss Blair consented to. Somewhere I have a timeline myself. Well, I know where I can find it.
Well, Mr. O'Donnell, let's do the best we can under the circumstances. At some point in time, and I think it was in December, the court said lifted the order saying nobody could be in there. Do you agree that it was about that time?
But we weren't given notice.
Did you ever ask Miss Blair if she could go in? If you guys could go in?
She wouldn't respond to our contacts, any of our correspondence.
And did you go in of your own accord
Where's that?
into the house?
Yes.
Okay, so you know, you say that you may have not been told by the court or Miss Blair that you were able to go back into the house, when in fact you did go back into the house at periods of time.
For possessions,
Okay,
to get our stuff.
and at that point in time, had the utilities been shut off?
No,
No.
no.
Okay, and did you ask for the utilities to be put back in? Put back on?
When?
When you went back into the house?
No. Why would we? I don't know what you're talking about. They were never off. I never went in there when they were off. Utilities?
Okay,
They shut off the garbage. She shut off the garbage.
but the utilities were on, the heat was on?
Yes.
Okay,
The lights were on, everything was on, water was on.
okay. Furnishings in there?
Yes.
You could have stayed there if you wanted.
What are you talking about? She was gonna have us arrested. The cops are out there every night. I don't understand. I'm sorry. I'm not trying to be rude here. I don't understand you. I don't understand what you're trying to say.
Well, if we knew when the order was lifted, I guess that's the key here.
I can't tell from the file that I'm in.
Doug said in that first hearing, I swear he said November something.
I have a note of it somewhere, but I can't find it.
I mean, why the judge is looking at that, Mr. O'Donnell? Were you there at a hearing where Mr. Coleman testified?
Yes.
And when was that hearing?
The first hearing was in, I don't even remember, to be honest with you. I forget the date of the first hearing.
Approximate date, fall, winter?
It was just January, maybe she filed in December, so maybe January, December 20th or something. Your first court date may have been December. She sent me something on December 20th when I got the lawsuit thing, and whenever the court was after December 20th, so it's probably January, I'm guessing. Ron, do you know?
Your kind of question, you said.
I'm just kind of waiting here.
The first hearing was set for January 6th. The defendant was served with a notice hearing on January 3rd. I can't answer the date easily on what date it was lifted. First set for January 6th, then it was going to be February 1st, then it got adjourned when Mr. Hatch got in the case. Then it got set for April 27th. I don't know the answer to that without suspending the record and going on a search. I thought it was in the zoning case, but there's very few notes in that file because it's a civil infraction.
Okay, well, Your Honor, I'll do the best we can.
All right. Consent order resolving the municipal infraction was September 6th.
Right.
Court accept the building official determination that the house was subject to being occupied due to structural damage. So there was no order that the court found that it was not to be occupied until September 6th. Then they were given opportunities to do other things. Now, this was all in the name of Rosemary Blair. There's no notice anywhere that any of this stuff was given to the tenants. And I can't tell, maybe I can see it in here. Because there was a subsequent inspection that it passed. It does refer to the tenants in his report, which I got at a later date. It's 84 pages long. I'm hoping to get to the bottom. Can't seem to speed it up. As I was leaving, I was advised there's a court hearing tomorrow at 8:16. This hearing is apparently a personal protection order where O'Donnell has placed a PPO against one of the neighboring property owners. Now, that report is dated 8:15, and there's no subsequent follow-up. I'm sorry, I don't have the answer in that file.
Mr. O'Donnell, were you aware that after the original condemnation, Mr. Coleman and others went out there and made changes and so forth, and the condemnation was taken off?
No,
You weren't there?
no,
You didn't ever
no,
talk to Mr. Coleman about it?
no,
You ever see the stickers go away?
no.
Stickers still there today?
I don't know. No, I don't see.
So
where it is.
here it is. Douglas Coolman. On November 16th, I received photographs and a message from Matt and Van Dam at Cruising to Construction. They had made the repairs that would stabilize the grass wall from the state of collapse. Matt has advised once they stabilize the grass wall, they will send the township photographs and they have the township's permission to remove the condemnation. At this point, the dwelling is no longer deemed condemned on behalf of Fabius Township. I have contacted the property owner and advised her the dwelling is no longer considered condemned. She may now enter the dwelling and move forward with her plans. So the condemnation was lifted by Officer Coleman on November 16th of 2022. Took me a long time to get there, but
By November 16th, Mr. O'Donnell, the pipes wouldn't have frozen by that time, would they?
No.
Objection to form calls for speculation. You can answer, well,
He's a builder, he
personal
says.
knowledge.
It's not freezing on November.
well, he's just gonna answer no because they won't. So why object? Just let him answer it and then we'll move on to the next question. No, the pipes wouldn't have froze by November 15th last year, would they?
No,
And the furnace wouldn't have just gone kaput by that time over that, was it 2 months maybe?
I don't think so. I don't know.
When did you go back into the house after November 16th?
Probably about a month later, October or something. I forget. I was in there November, October. I was in there a few times.
And was there furniture there?
There was some,
Yeah. And the lights and the utilities all seem to be working?
for the most part, yes.
And you could have moved in there if you wished?
No, because how could we move in there when they have the police coming after us?
Police come after you after the November 16th?
Yes. On November 15th, they came after. She called them on me on November 15th.
And after November 16th, did they come?
Yes, October, they came out again.
No,
November.
that's before November. Did Mrs. Blair ever advise you that the condemnation had been lifted on the premises?
No, she did not.
Did Officer Coleman ever advise you as the
No, he did
tenant?
not.
So you didn't know the condemnation
Not
had
until
been
we were in
lifted,
court with you, Your Honor.
which was January 6th.
Yes,
And by that time, you knew it had been,
we heard about that day in the court.
okay. Did you move in after that?
We weren't allowed to.
I prohibited it.
After that time?
I said nobody was to go in there after, till we sorted it out.
Very good, Your Honor.
Anything further?
Nothing further.
Nothing further with this one, Mr. Howard. I think that's good. Yes.
All right. Do you wish to call Ms. Bowers?
We do, Your Honor. As our second final witness, we will call Carla Bowers.
That seems like a good place for us to take a brief recess. Next time, we will hear from Miss Bowers and hopefully get a verdict. Thank you all so much for watching. We really do appreciate it.